the definition of frivolous conduct. Mr. McTighe wants to add to the statute. He wants to add an intent to harass or an intent to maliciously injure. It is not there. Frivolous conduct means conduct, quote, it obviously serves merely to harass or maliciously injure another party. Period. That's the statute. It doesn't say you have to intend or deliberately injure or harass. The question is Ms. Ice-Kirkin, by the filing of the false affidavit accusing her of violating the law and summoning her to the government, did that harass or maliciously injure her? Period. That's what the statute of frivolous conduct is there for, to prevent stuff like this. Don't add to the statute. It's not proper. It's not consistent. She was harassed. She was injured. She never have had any dealings with the government. It was frivolous conduct. Thank you.
Bill, in the history of the commission, how many cases come before us that there was a charge of frivolous that were actually found to be frivolous?
I think it's approximately eight over since the commission has become an independent agency. I think it's 8. I didn't, prepare that kind of information coming from this, but it was an issue in a case the commission decided about 2 years ago, and it was 7 at that time. Subsequently, we had 1 more that's currently being challenged in the appeals court, the District Court of Appeals. There were a couple more prior to the commission becoming an independent agency. So that's the number of times the commission's actually found the matter frivolous. It's been requested, I don't want to say often, but it is something that has been requested, and the commission did not move to find the matter frivolous.
And would you or would you not agree with Mr. McTighe's description of what the actual standard of frivolous is?
Well, we just heard Mr. Hartman talk about the nature of intent. You heard that. I'll let you assess that if you believe appropriate. Certainly there is an element there. So I guess I would say knowingly, or improperly bringing something before the commission and obligating the commission to proceed in a situation where you have an idea that something was improperly done. Or not, I shouldn't say improperly done, where there was an allegation against someone and there was no real basis for it.
So it's essentially the knowingly standard.
I think there are parameters that in there
Okay.
that has to be considered. Yeah.
In 5 minutes, give my personal view of it. I don't see how you can do something maliciously, just clearly without intent. Otherwise, it would be accidental, right? I mean, I think take the definition of maliciously, intent has to be a part of it. That's just my thought.
Fairly.
Question, with respect to the service of the response to Mr. Berneri from Ms. Spoken.
The rules specifically obligate a respondent in the freedom case to, along with submitting it to the commission, to also submitting it to the complaint, the other side. I will say that on a regular basis, not necessarily a complaint like this, but it's not out of the ordinary for respondents to submit responses to us and not necessarily send them to the other side. If requested, I will go ahead and forward them along to a complainant when they are submitted to us, but I do not regularly submit, forward them along unless I receive such a request.
With that explanation, why would we want all parties to have all that are involved in the case? whether they request it or not, Mr. Berneri would know to request it.
I'll rely on the rules that obligate the other party to submit that, you know, I mean, you're certainly welcome to say we should be circulating materials after we get them. But, you know, in the since the commission's been an independent agency, I've been responsible for it. We have never subsequently sent along responses after we received them. I want to think that that's always been the way the commission operated, even prior to it becoming an independent agency, when it was, you know, administratively handled in the Secretary of State's office. No, you know, there was no other reaching out to a complainant of materials that were submitted. Now, I can't recall whether there was a specific obligation in the rules, because I'm not recalling the rules from back then. Certainly it's beneficial, certainly, I get this there, but by our rules, the obligation is only be responded to take care of that responsibility.
And I guess there are different concerns, like, you know, I've got some concerns about how government doesn't share information with the public on what the rules are on a regular basis. So, you know, Joe Blow out here, you know, has responded, they only have to share information with the commission. They probably think that the commission is going to share them with the complainant. You know, I think everyone involved in this case should have the information, whether we change it or not, or whether there needs to be better communication through the Secretary of State's office or on our website or whatever the case may be, so that everybody is aware of all the information for that particular case, both the respondent and the complainant.
Okay.
Because not everybody has an attorney to represent them, and you're not required to have an attorney to represent them.
Madam Chair, if I can ask a question to the executive director. So just so I'm clear, this is a hearing to determine whether a matter is frivolous. Frivolous. And then subsequently, if we were to find that it's frivolous, we would then have an additional hearing to determine the severity or the amount or the sanction, if you will.
Yes, that's how the commission has operated in the past when we have had these kind of matters brought to us.
As it relates to Mr. Granary, I think his testimony today came across sincere. However, he had the responsibility to make sure his filing was accurate, and it wasn't. The photos are not even worldly close. And it really concerns me that a complaint is filed, and then a young lady from Hamilton County has to, answer counsel, whatever, answer a complaint. And this was a mistake from Mr. Granary, and I appreciate you saying that it was a mistake. But sometimes when we make mistakes, there are consequences for those mistakes. And I do feel that some consequences are merited here, not severe. That's part of the reason why I asked him an apology earlier. I mean, I think you owe the lady an apology at the very least. But, part of my concern is that, we went through the levers of government here, to get to this point. The lady, sent an affidavit. She clearly didn't have a binary heart. The pictures are dramatically different. So I just wanted to put it out there that my feeling is that this matter, as it relates to Mrs. Iskirchen, is frivolous. And I do think that there should be mild sanctions. So we had to have a starting point somewhere. So
My reply to Mr. Garrett. So, I politely, respectfully, but adamantly disagree. I absolutely Mr. Kirkin, didn't have to go through this, and I feel very, I'm sorry that this happened. But, as I look at the signs, they all look very similar. I mean, almost spot on the same. So I think it's very reasonable and actually quite possible there was some coordination of this, right? You can even get into whether there was like a pact violation. Where do I go?
I think you did one of them.
Yeah.
Right.
So, you know, but that's not what we're here today, but the very, very reasonable, right? And Mr. Grunieri, I mean, I asked very specifically, there is no connection, or gets paid to live. There's no reason whatsoever, or, I mean, there was the reference to the folks across the street, well, whoever his name is isn't on, right? So if that was the intent, it would have just not even been mentioned. Also, you know, if he could have validated it, absolutely. But I mean, people make mistakes all the time. And in terms of, you know, if you look at the pictures, you're right. If you take a close look, right, and start to dissect it, they are not similar. However, I probably have the unique experience of having done engineering tests of manufacturing floors where operators have to see certain things taking action, and then you run a control where that is even happening. They will take the same action and tell you they saw it. So, you know, people, and it's actually, there's established research on this. When you're looking for something and you expect it to be that way, oftentimes your brain believes it. And these are similar enough that if you're expecting it, I could see where that would get overlooked and a mistake would be made. If Mr. Grunieri was trying to overtly be malicious, which is this frivolous thing he's talking about, he would have included the auditor piece, because the auditor is the different one, but it's in his complaint, right? So it wasn't trying to hide it. It's very, very clear to me that he made a mistake. It's horrible that it affected Mr. Kirkin that way, but it doesn't reach the standard of frivolous as I've heard it today, in my opinion.
I'm gonna keep longer, just saying, when we originally received this and I saw these pictures, I thought, why is this picture in there? Because this is the house. Well, then like when you actually research it and find out this really isn't the house. I guess when I just saw it at a glance, I wondered how couldn't tell that that's not the same house. So I do think that though it was a mistake, I do think harm can be done. Even, you know, obviously it was, you know, not. We heard testimony that wasn't an intent to harass her. But harm is done regardless of whether it's meant to or not. So I don't know the second definition that Mr. McTighe read, that, you know, the evidence. So the evidence does not support what he was saying, but yet he submitted it anyway. And the harm was done in submitting something that was incorrect. And so then to the point where this lady goes in, this Ice Kirkin goes in, retains, you know, legal counsel. And I'm married to an attorney who, he doesn't think twice about going into court because he does it every day, but to someone who has never encountered the legal system, it's very dismaying, or it might be, you know, something that gives you a lot of general stress in your life, because she can't understand why, when it doesn't even look the same, why is it still being pursued in her name? So I guess from that aspect, I don't think we can discount the fact that she's spent funds and had time and stress and angst and dismay, as she said, over the fact that something, if it would have just been researched a little bit more, could have been avoided. So is it frivolous to say that this is what I thought I saw, so this is what I submitted?
I don't know, to me, there has to be something that would make people maybe look a little closer at the evidence that they're presenting to this body or anybody. Because this may seem like not a big deal. This is the Ohio Elections Commission, you know, we don't hear murder, but what, you know, I think that it's just really incumbent on whoever's submitting the evidence to make sure the evidence is correct. And in this case, it's not, and it has caused harm. It has caused financial, you know, a financial burden to Miss Ice Cricket. So I think that is it meet the definition of frivolous? It meets the definition of causing harm. So I don't know. That's my opinion. So.
Madam Chair, if I may, I'd probably say something to everybody, man, on this one.
Oh, good.
So, but when I look at it, I think Ms. Tavares hit the nail on the head. I think it's an issue, obviously, with the commission and the way that it's structured. Obviously, I understand it's a trying to say it properly. Ms. Skirvin?
Ice Kirkin.
I apologize. But you know, I'm good close there. But I apologize, you have to go through this. Obviously, cost of attorney fees too. However, still, when I look at it, I see there's a responsibility that we have to look at standard. And I don't believe there's actual knowingly intent. I don't believe that it was blind, I'm trying to think of the term, blind intent here. I think it was an actual mistake going through the forms, but I also understand what she had to go through, and I'm sorry for that. I actually think it's a problem with the commission. And, you know, this is where I'm gonna get everybody mad, but I really think we should pay for her. I don't believe that the standard was met. But I think the commission, because of the way that we do not put our materials out to everybody, that we should pay her legal fees. I'm just saying.
Motion.
Well, I mean,
We don't know how much they are.
I I know what they are, but yeah, I'm probably outside the pale, obviously. But I understand this is a problem in the system. And that needs to be corrected. And that's why I'm saying that. I mean, I understand she's apolitical in what happened. And there is, you know, obviously caused her some sleepless nights. But then, unfortunately, the way the system is scheduled or set up, I still don't see the standard being met. But I do see what's happening to her. And again, I apologize. So, and I know nobody probably agreed with me, so I would make a motion there.
Yeah.
I'll let you know that's wrong.
On Mr. Lyle's comments, I agree. I don't think the standard has been met with respect to frivolous. I am concerned about our giving materials to all parties. That's serious. And both parties have had to entertain lawyers. So Mr. Berneri isn't without expense as well. So, you know, as we look at this case, there are things that we do need to correct. I definitely feel for Ms. Ice-Kirkin. You know, she's been apolitical for a reason. Whatever her reason is, she's chosen that. But I do believe it was a mistake. I don't believe that the intent was to harass. I don't believe it was to do harm to someone that you don't even know. And then we learn that the person is apolitical. So there would be no gain from anyone. I'm not managing. With respect to.
Mr. McTighe probably is, because I didn't say covered his fees.
No,
It's a good point.
It was a good point.
His client did something. My client didn't do anything.
I'll just say that.
His client did something.
But I also think if you're the person who's bringing this to the forefront, or if you're making a complaint, then you should be prepared to pay the legal fees. This, this ice curtain was not in any way. While I know that maybe he didn't know her or Mr. Daly, he said he didn't know Mr. Daly and his daughter, but clearly his intent was to make his point.
We get those every day, right? We get others, ours to go after, they're not going after ours, they're going after D's for all this stuff and vice versa. That's what we see. That's just no different from that
That's my
perspective.
point, is that I don't, you know what I mean? So he brought this for a reason, and so the harm has been done. From someone who had no dog in the fight. So I just think that there's just some kind of basis for. I agree with Mr. Carey that there should be some kind of sanction that's made, but apparently I'm in the minority. So, but I do feel, I'm gonna say my piece, which is harm has been done, and I feel it was out of line. So that's my opinion.
And I would agree, harm has been done, but again, his complaint was no disclaimer. That was the complaint. And a party was included in it that was inaccurate, but there was evidence that he did what he thought he used to do to get the parties that had the signage. I don't believe the burden's been proven by the respondent. And, whether we agree to allow for some payment of attorney fees from the commission, as Mr. Lyle had proposed, that's a different story. I just don't believe the burden of proof has been met.
I would have to agree. I think, I thought the complaint that we heard the other month about the signage was very legitimate. I thought the complaint was a legitimate one that we heard. I do believe Miss Eustachian,
Ice curtain.
Ice curtain.
Ice curtain, ice, but not.
I believe she was, I don't think anybody here disagrees. I think it's the burden of proof as to whether it was frivolous or not, and I just don't see that.
I'm gonna make a motion to, see where it goes, to dismiss the claim of that it's frivolous. But I also would add that for Ms. Ice Curtin, like I said properly, this commission should pay up to $5,000, not to exceed $5,000 for her legal fees.
I'll second.
Can we have some budgetary discussion?
Yeah.
We have an
That's
election.
what I
board.
just
Yeah.
We have a motion on the floor.
You have a motion, you have a second, now you have discussion.
Is
No
there
sales man.
I second.
You seconded, okay, I didn't hear that. I have no clue,
That's what I said.
only because that's something that, we've never dealt with before. So there are a variety of things I try to be prepared for, that wasn't one of them. Not that I have a problem with you, raising that issue, you want to go that way. But I think if it becomes one of the better phrase, valid expense of the commission, is it something the commission desires? I can at least look into it, and see where it goes from there. That's the best I can offer you this minute. So, because we paid legal fees at various times. Well, for council to represent.
There is a lot of percent us.
Yeah.
So my concern is that, we're talking taxpayer money that we're using to make this reimbursement.
She's a citizen.
Well, yeah, but there's however many citizens in Ohio who may not agree that's a good use of their taxes. Now we're making decisions on how to spend people's taxes. And you know, we're recorded from my days in the auditor's office. I can see this ending up in the papers that the elections, all kinds of calls the governor's office. What are they doing? Spending taxpayer money to reimburse legal fees. Whether we agree or not, it's likely to create angst. And I'd be hard, though I think it's the right thing to do. I'd be hard pressed to vote in favor of reimbursement for some of those reasons.
And I just, on that point, and I certainly understand and agree with much of what the reminder, has just shared. But to the executive director, we have general revenue funds that come in to support the commission and the work that we do. But we also have the fees and fines that we generate, which isn't taxpayer dollars.
Sure.
Could we look at it through those lens as well?
Yeah, I mean, there, you know, yeah, we've got two, more or less, two pockets from which there are expend, you know, from which we make payments, let's put it that way. And so there is that. There is that.
Madam Chair, if I may, follow up on his comments, Commissioner Weil, would you be willing? I agree with you. I don't know what the number would be until we heard from Ms. Ikirkens, you know, what those fees would be. Would you be willing to split that motion or to revise the motion to say, upon research of the election commissions, the staff of the elections commission to come back with us with a recommendation rather than setting a monetary amount today?
I could, yeah, I think the easiest way to do that would be I would have to withdraw my motion. Mr. Barnes would have to
Yeah.
withdraw her second. So I can withdraw my motion,
I withdraw my second.
and I'll make a second motion to deny the claim that it's frivolous. And in addition, that the commission, if legal, and if it's legal, that we would then ask Phil to come up with a recommendation as to how much we would pay Ms. Ikirkens with respect to legal fees. That makes sense? You should agree with it, but does that make sense for others?
I understand.
Do you understand what I'm saying?
So you're saying the harm was done by us by not distributing?
I go back to what Mr. Tavares said, and I fully agree with that. I believe it's on the commission. Obviously, Mr. Ranieri said if he knew that, he would have withdrawn the complaint. I have no reason not to believe that he wasn't telling the truth. And, you know, I have a labor arbitration background, so, you know, people get all the information. I mean, it's just the system. I'm not blaming you, but I agree that we should be sending out more information to all parties involved.
I would second that motion.
Discussion.
Once discussion.
Yeah.
So the motion is dismiss the list and have the director come up with a recommendation.
If legally possible.
If legally possible, but with the recommendation, if it's legally permissible and possible, include a number.
I think his motion was to leave it up to the
Yeah,
recommendation.
it was a
of the executive director.
recommendation.
Okay, so we made during, well,
And
that,
then we would have to vote on that.
okay, great. Well, I would just like to throw in that as a, well, I guess I would ask the question as a part of that recommendation, should this motion be approved, anticipate asking Mr. Hartman for his invoicing
Yeah.
between what the costs are?
Yeah, I'll get my information I can get my information to Mr. Richter prior to the recommendation, so he can include whatever with the recommendation. That would be.
Right, that's
Yeah, because right now I'm currently zero, but you know, that's.
You got to see us again. Right after that.
Yes.
Just off the top of my head.
fine.
Madam Chair, one, if I may, not sure if this is proper or not, but the one thing that, I believe that, Mr. Granieri, I believe that there should be sanctions for him. I think I established that earlier. It is clear to me that I'm in the minority, and that's okay. That's what this commission's about and debating and talking about. Although he would be under no, legal obligation to do so. I would be knowing that she could be made whole potentially. I would be willing to vote in favor of Mr. Lyle's motion. However, I would like to know if Mr. Canary would consider writing Ms. Iskirk a letter of apology.
Absolutely.
And you're saying yes, you would.
Yeah, yes, yeah.
So I think properly, we would need to have you amend my motion. Well, let's say this, how you
No, it's
do it.
true. Yeah.
You have to amend my motion,
And I'm going
and then I'm the maker of the motion. I can just say I will accept that.
to second it.
So you want to make that motion just for,
Will you make the amendment?
Yes, Madam Chair, I would make a motion to amend his motion.
you should be at a union convention. And it goes 20 deep.
John, I've never been invited to one. To ask that Mr. Granary do write a letter to Ms. Iskirk and offer his sincere apology.
And I'd accept that as a friendly amendment.
And I would accept it as well.
So we have a motion. Duly amended and seconded. That is on the floor, and I will respectfully ask Mr. Richter to do a roll call vote, please.
They finish writing first.
Sorry.
I have.
Okay.
Do you want to repeat the motion, Phil? Mr. Richter?
I don't know that I want to.
Well, I mean, would you?
Oh, yes. Yeah, the motion is to deny the request to find the matter frivolous, but to also investigate, come back to the commission as it relates to the commission paying certain legal fees of the respondent is Iskirchen, excuse me, based on information that I will get by talking to whoever I need to talk to and Mr. Hartman, and to also include that Mr. Granieri will send a letter of apology to Ms. Iskirchen. And all of that has been properly moved, seconded and accepted by the movement, Mr. Lyle, and by second, Ms. Ibarra. And my first question goes to Mr. Colby. Do you approve that motion? Aye. Mr. Knight?
Aye.
Mr. Caraway?
Aye.
I'm persona non grata.
Mr. Lyle?
Aye.
Vice Chair Tavares? Chair Kaufman? We got until 5 o'clock.
So that motion.
Anyway, that motion carries by a vote of 5. There's one item left on the commission's agenda for today.
So,
So I don't know if
Mr.
someone,
Gary, yours, and I think Mr. Retired.
Mr. McDyke is excused.
Thank you.
There's different files. Thank you. Thank you.
Okay, so you're getting 5 minutes.
Yes, yeah, it is.
And then,
Yeah, that's it there.
10 minutes, 1:44.
That's the. Yeah, it's really good.
We have.
I'm not. Hold on.
Just you.
I'm not, he thought I was on it. Oh, okay, if they have questions.
Well, that's all.
Should I read what you guys filed? Was it interesting?
No, oh, the memos?
Yeah, memos, the motions.
We didn't know we got this
Oh, yeah, right.
We get a wire transfer.
Her name on it, yeah.
And that's all we did. And we looked it
Yeah,
up on some system and it had all this information.
It should have been on our website. That's true, because they put lots of people who don't work a little part, yeah, right.
Yeah, but they do.
We've been there. Where she worked.
On that.
Yeah.
So,
Well, it's probably a left-hand, right-hand thing, right? I don't know.
What it's got.
It was only 4, it's gonna be time. So.
Yes, yeah, that's why, yeah. It's even more, right?
Not just the.
Yeah, no, I see it.
Yeah, good thing.
I appreciate it.
That's it. The way that it is. And the problem is, I think you gotta go merge the merits, whether or not, okay, if the signs are perfect, okay, I can understand that. Okay, maybe it's balance the signs. Somebody. I think.
Right, but it still goes to, in my, I mean, when I'm looking.
I mean, what gravity do we attach to an affidavit? Nothing.
Well, but it's the. I just, I understand what you're saying.
Should have known that was not hers. He
No,
took
I-
the sign, he took the picture,
Yeah, that's what I.
he knew or should have known.
I understand. what you're saying.
Not know, maybe should know or should have known. That, you know, the fact that, okay, he wasn't going after her, fine, but he put false information. That, it's more the false factual stuff.
Oh, yeah.
As opposed to the, you guys got focused on, there was like four different bullet options for which frivolous conduct.
Right,
You guys got so fixated on, was the intent to injure her? One of the other bullet points is, no factual conventions that have no evidentiary support. What, that's a separate thing from the intent. If this was found in a court, he'd be sanctioned. And that's the statute that big court attorneys and clients get sanctioned in court all the time. Did he just have factual support? No.
I hear what you're saying.
No. I mean, Mr. Bars have been against this from the beginning.
Oh, no, I'm not.
You guys didn't even want to go to this hearing today. You voted against this last
Well,
time.
I did, but I based that on my recommendation of the executive director also.
You got a thing for yourself.
Well, I didn't think for now, and I think for myself, you're like, what are you doing?
Phil is not always right. Phil is often wrong.
Well, I know that, and that's why a lot of times we overturn what he says. I mean, I'm
Sometimes.
sure he's not happy with me either.
Sometimes you return with it. But that, I just think you guys sent the wrong message today.
You're entitled
You can
to
put
that.
a false affidavit into a government body. And there's no ramification. I think Steve got it more right. He was wrong. You should have some accountability. I wasn't looking for the evidence last. I was hoping you'd at a minimum say yes, it's frivolous, maybe even frivolous, no fine. But even the declaration.
Well, that would be fair. You
Why?
could-
Well, now, I heard,
That's not.
but at least it admonishes that he now would have the label as filing a frivolous.
Well, I think that's what the apology is. I mean,
Honestly, I'll tell Steve, we're not in kindergarten.
well, I
The
understand,
apology letter is a kindergarten thing.
but it may mean something to her. May that mean to you as an
Tells
adult?
tells about heart attack. That's what gets me to Bell has been.
Well, I can't fix that.
I know.
It's a community. You know.
Oh, it's a crazy community.
Yeah, that's.
They're crazy.
It sounds like. That's.
Chris to deal with this.
Beautiful day.
Yeah, we've been in here all day.
Well, when I checked up in Cleveland yesterday morning, they said rain all night and most of the day.
Uh-huh.
It was beautiful drive down.
Oh, wow, yeah.
I bet you when we come down to 2 weeks, the drive for me is gonna be gorgeous with all the trees changing. They weren't there yet, but I bet you
Yeah, we're going to,
that's in 2 weeks, right?
yes.
That's
Yeah,
when the
the
England-
25th got rejected quickly by Mr. Lyle and Mr. Knight. Sure, Mr. Hicks will figure out how to complain about it still, because his nature. That's doing
But we have fix on that.
on the 26th.
Yeah, 26. He wanted the 25th.
Yes, he thought about having an extra day, just in case we need more time, then he could try and bring the Stewart case back. It's like. Yeah, we have to deal with him on a whole other couple.
Right here,
Hello.
right here.
This Kaufman I'll talk to, I'm not talking to anybody else.
Well, Phil, respect.
No, I'm not talking to, respectfully.
Respectfully, you have to, listen, I haven't been in my office for a week. And I am not there today. And remember that email, today's meeting, should have last morning.
I said,
Yeah.
what else did I say?
Okay. I know what you said.
Yes, and why did I say it was a total yes?
Had an audience.
We have a certain.
Why did I say it was a total yes? It has come to fruition.
So many friends of mine have told me, don't hit that send button unless you're absolutely sure.
That's exactly right. We need to counsel more and more people with that.
Oh, now it's supposed to be rainy on Saturday. My wife and I are going hiking in West Virginia this weekend.
Oh,
Yeah, he follows. She's been following the weather for a while, and it was supposed to be nice on Saturday and raining on Sunday. Now, it's also supposed to be raining on Saturday. That's what
Really? We got a rain season list. Did you send the place?
Rarely, although we went to, last Friday, here in Columbus was, Jesus Christ Superstar, which we did go to, that's the first play.
We. It's pretty wild.
Yeah.
Pretty one of the seasons.
Saturday is gonna be 65, which would be nice now, but then Sunday, rainy and 36. Be a little chill.
That's the Cheat River. It's down in West Virginia. Isn't it?
I know the Blue River is, I'm not gonna disagree with you.
Because it's up.
This is nothing to compare to the 7.5 hour hearing I had yesterday, Board of Elections,
Hamilton County or wherever.
Ashtabula.
Oh, up our.
What was going on up there?
Challenge to the voter registration of the county prosecutor. So I was special counsel to the Board of Elections.
Voter registration, county prosecutor. Where was he?
But
She, or something not registered. Or
they claiming Cuyahoga. It got rejected 4-0.
So you were counsel to
BOE.
Board of Elections, and you brought the case that she was.
No. They were the trier
Oh,
of fact.
somebody else. brought-
Another complainant brought it. I just got it. Yeah. Well, there the key evidence is you got the complainants have to prove the person is not a resident in the county, so they got to prove a negative. Ms. Tavares, did I hear you were getting reappointed to the commission?
Don't know yet. You have support. We just need to get that out of Democrat.
I mean, I would, for, he is eligible for reappointment
Which I disagree with.
because she has not served a full term.
I think she's eligible.
Yes, there have been other people that have been reappointed.
Oh, I know that. I know the commission does that, but I don't think it complies with state law.
No, it's not us doing it.
It's still, yeah, it's the governor through the General Assembly. I know that. Yeah.
Well, that was the witness there too. Pressure. Let's say,
Oh, last one.
a light,
Now Don's over there messing with the system.
No, I think this may cool it down. I could be wrong, but we'll see. Yeah, it's 70s. 75 in here, which is about 60. Please, about 60. You're allowed to get out of the approach.
You gotta make an executive decision and say yes.
I'm gonna overvote, I get some salt and something sweet now.
Okay. We got like 4,000 calories sitting over here on the table.
I search firm water, something that's remotely healthy in machine.
That's it.
Okay. It is 1:57. Let's call meeting back into session. Okay. So the next item on the agenda is hearing for case number 2022G-021. We have Mr. Hartman here.
right, but I don't know that it would be appropriate for Mr. Hartman to address the commission because counsel for the respondent.
This is where we submitted the written arguments. We agreed the facts were generally not in dispute. You have written arguments or memorandum.
Madam Chair, members of the commission, this is a complaint that asserts that the individual respondent was credited with making certain contributions for which he did not have sufficient monetary resources to probably make those contributions, and that the recipient of those contributions improperly reflected the individual as the recipient when she was not the actual contributor. That's the complaint. We received responses. We have also received memoranda from Mr. Hartman and Mr. Hube on behalf of the Ohio Democratic Party. Ms. Rakowski, who is the individual respondent, she submitted a response to the original complaint. She did not submit anything further at the time that Mr. Hartman and Mr. Hube submitted their responses over the last couple of weeks. She is aware that this matter was going forward today. I informed her of it. I believe I sent her the materials as well that were submitted. So you all have received all the materials to presumably put yourself in a position to make a decision on whether there has been a violation of the statute as alleged in the complaint. Madam Chair, I'll turn it over to the members for their deliberations, I guess I should say.
So conversation amongst commissioners, comments.
I guess,
It's my eye.
Madam Chair, the thing that struck me about this, that I will admit to you is this was very interesting for me to, read all of the material rather than, actually hearing some of it. But the thing that concerned me the most was the volume, the amount. I think any political operation, when you're dealing with millions of dollars, which inevitably ODP or ORP or whomever would, when that kind of volume of money is coming into the political apparatus, it's known. It's like knowing, wire transfers are taking place, et cetera. So if I read the material properly, it was the Ohio Democrat Party, just so I understand, Mr. Richter, it may be helpful for all of us to make sure that we all understand exactly the circumstance that the Ohio Democrat Party filed campaign finance reports that attributed the contributions to or from, what was the name? Sorry.
Rakowski.
Ms. Rutkowski. She, at the time, as I understood it, worked for the Hamilton County Democratic Party.
She was the interim executive director of the Hamilton County Democratic Party at the time of those contributions were made, correct?
And she was making wire transfers from what appeared to be a software from ODP's account, or I'm sorry, from Hamilton County Democrat Party's account to ODP.
There were electronic transfers of funds. As I sit here, I can't remember how many off the top of my head. I think it were 12 separate contributions. That totaled over $440,000 from the Hamilton County Democratic Party to the Ohio Democratic Party through a period of time. And all of those were attributed individually to Ms. Rakowski instead of the Hamilton County Democratic Party.
Right. And to be clear, the contributions from the Hamilton County Democratic Party to ODP would have been perfectly legal and would be without the confines of contribution limits, correct?
There is no allegation that any of the contributions were improper.
Okay.
And based on my looking at materials, yeah, there is no violation of the statute there.
Okay. So the bottom line is, I don't want to mischaracterize, but the way I read it, it's clerical error. Said,
Well, each
Yeah.
person has, all the materials are available to them based on, the complaint, the responses. The memoranda from Mr. Hartman, the memoranda from Mr. Hubei, that lay out the respective positions of the respective parties as it relates to what occurred. I think I'd be remiss if I tried to impose my interpretation on all of you in terms of, what all of those things say. I think that, that's certainly probably fair to say that that's Mr. Hubei's position. Is that, that's the information that they got from the bank. And so that is what was reflected in the campaign finance reports. How you want to interpret that, each individual's has their own review of the material and interpretation, but certainly that is Mr. Hubei's assertion on behalf of the Ohio Democratic Party. They simply, more or less, relied on the information they received back from their bank and when the contributions were received.
yes, my problem is they may have relied upon the information that we have a volume of money. I view it as more of a due diligence. They should have done additional due diligence on $400,000+. And I'm not sure what the purpose of the expenditures were. It could have been mail pass through or whatever.
Wondering how that was processed, that it came with her name as opposed to a business name.
Yeah.
That's my question, I guess, that's been what's troubling to me is that identifying the contributors, Mr. Rakowski, based on information that they received from their banking institution at the time, the contributions were deposited into the party's account, but why wouldn't it come from Hamilton County?
Wires get processed and I'm experiencing one right now. My venture capital firm, it was called Capital Calls for our investors. Bring money in, we make an investment. And some of them ACH, but a lot of them wired. And about half of them come across with no name, no nothing whatsoever. And we're, like I'm doing, we deal with that when we finished today, having 3 phone calls to make. Or to identify 2 transactions that there's just no identifying information. And since while they were the same amounts, if they're different amounts, you say, well, this amount was to this person, but they're the same amount for a lot of them, say that's the same, I don't have any clue. So I'm not gonna make calls and look stupid, right? Did you do this? Did you do that? So I figure out. So,
So that's not really concerning.
not to me, that part of it, I mean, I agree, you would expect with those levels, there would be a alarm bell and that would require more work. However, the statute reads, shall knowingly conceal or misrepresent contributions. It doesn't say, you know, you have to perform a certain level of due diligence prior to the reporting or you hit that statute level. Now, clearly there is a, you know, well, a violation that the report was wrong that they fixed, but this particular statute, I mean, it should have did more work, but I didn't see anything that proved knowing concealment.
Madam Chair, if I can jump in there. So I think that we need to look also, as we've experienced here at this commission. But I think it's important to remember how all these agencies run. So we have the Ohio Democratic Party, you have the Ohio Republican Party, Hamilton County, obviously, a party, and by experience we've had. We know that when people come up, and we're witnesses or just the way it works, most of these folks are, I'm not gonna call them kids, they are to me, but they're young adults. And they come out of college, they get a little, you know, poli-sci degrees. And nothing wrong with that. I'm not trying to denigrate that. But I mean, they're looking obviously to work Republican Party, they're looking to work Democratic Party. It's a resume builder, right? And I think it's important to understand what's going on at the Hamilton County Department, Democratic Party, and also the Ohio Democratic Party. So we have had, I'm going to get to that in a minute, but we have had, to make a point here, the Ohio Republican Party was in front of us probably a year ago. We were all here, you were here, I was here. The two, Loki was not, no, Mr. Farley was not.
Late for some.
They missed, they did not do a filing, and it was, memory serves me right, it was way past a month, it had been a month and a half, 2 months. And basically what they did, there was a change in leadership, right, which is gonna be my point here in a minute. And they said that they're, you know, they just missed it, it fell through the cracks. These kind of things happen all the time. Now, I'm not suggesting that we don't find violations, but I'm suggesting that we ought to look at these institutions or agencies as how they run. Now, I know you're from the Cincinnati area, Hamilton area, and down that way, Butler County. In Hamilton County Democratic Party, there was an individual still alive, a good attorney by the name of Tim Burke. Tim Burke ran Hamilton's Democratic Party for 24 years, right? Good law firm, never any issues. He leaves, the person that is there, okay, so he's chairman, right? He's got an executive director, a person that stays there. So they stay there for a year. That person retires or leaves, and then they get another person who's running the day-to-day for 2 years. Does an excellent job. We never had any cases up here in front of us, no problems. Now comes Ellen Murkowski, who I do not know. But she is, if you look on Lycan, you can, a lot of you have it. She, as Phil said, and as the facts are not are stipulated here, she worked for 8 months as an interim director. Prior to that, he was an outreach director for the Hamilton Party for 4 months. They have no clue about campaign finance, is what I'm saying, right? There is also, at this point in time, there's turmoil in Hamilton County because Burke leaves, they have co-directors. And then the co-directors end up coming down to one finally, she's put in there. Is she qualified to do the job? I didn't hire her, I don't know, but she's a newbie is what I'm saying, right? Also, kind of a perfect storm over at the Ohio Democratic Party, another Cincinnatian, David Pepper, okay, he was the chairman of the Ohio Democratic Party. He's gone at the end of 2000. Right? So now you have, David's gone, you have a new director, and as you guys all know, you're all political, you know, as new people come in, new young adults get these jobs. Now, if you had somebody like Tim Burke, who had been around, and you had that institutional memory, and they were working at the Democratic Party, it would seem to me that if I knew who Helen was, that would have been a red flag when that got wired to me. And I would have said, you know, okay, that's not right, Ellen, you can't do that way. So my point is that they have this constant churn. We've seen it in both parties. We found violations for the Republican Party too. But it's really kind of the way the systems are set up. You know, you would think, I thought years ago, like, oh, they were, you know, like the folks that would know how to run everything. Well, that's not necessarily the case. And I think we got to keep that in mind because the way that things, you know, turn. So, and the other thing, when we had the Republican Party in front of us, and I had asked Bill this question, and, you know, you would think we hold them to a higher standard for routine based on what our director said. They're the same standard as anybody else who would make a violation. And then we need to look at it that way. So she's the interim director for an 8-month period. Like I said, you know, we had Burke is out of there. We have all this stuff going with the Democratic Party. You know, God knows that what happened. Now it's conceivable, obviously, as Ernie was saying, that somebody who's doing an accounting function just doesn't know what they're doing either. So we have this error. Now it's a big number. I'm not going to say it's not. I've read both of these briefs 3 times. Mr. Ube's brief, Mr. Harmon's briefs 3 times, looking at them. And, you know, as soon as the complaint was filed, we know the Democratic Party now makes a correction. So it's not like somebody was playing funny with the money. It's not like somebody absconded with the money. It's like, yeah, we screwed up. Okay, we got to fix this. And they fixed this. And then, you know, if you go on, and I believe, as you said, Mr. Caraway, when I look at this and I know the way these agencies run, I believe it's just a clerical mistake. Rakowski, obviously, you know, she's in the big league. So this isn't like a Warren County or a Wood County. All right, this is, you know, you have Cuyahoga County, you have Franklin County, you have Hamilton County. Those are the big parties for all of us. And if it's Republican or Democrat, right? Those have more volume, they have more things happening. You have, as I said, you have new directors everywhere. It's not inconceivable to me that, you know, it fell through the cracks. Somebody didn't know what they were doing, but then it comes back to, again, and as, you know, Mr. Ube states here, in his brief on page 6, let's see. He says, any information ultimately discovered to be incorrect on ODP reports was provided innocently and inadvertently, but not knowingly, as ODP did not know that the contributions from Ms. Rakowski were actually from Hamilton County Democratic Party. I mean, come on, why didn't they know? Well, left hand didn't know what the right hand's doing. There's obviously no connection here. There's obviously a turn of what's going on, right? People trying to learn the system. Courts distinguish acts committed knowingly between acts committed innocently or inadvertently, U.S. versus Mendez. One knows what he or she is doing. The knowingly means that one knows what he or she is doing as distinguished from an inadvertent or careless act. Okay, and like I said, there's nobody playing fight with the money with cases we have obviously coming before us that could or could not be the case. Nobody absconded with any money. It was reported. Was it a violation? Yeah, it's clearly a violation, in my opinion. So, how do we, so we have to deal with it. I have thoughts, but I guess for all those reasons, I would say that, you know, we find a violation and there's a minimal fine. So that's where I'm at.
Yeah, I was gonna say, what stuck out to me was obviously the size of the contributions. You know, it really worried me that somebody who's so young, and it's LinkedIn, John, I know you say LinkedIn. but-
That was my bad. I apologize. I know what it makes sense to me.
Never heard of that.
I know. Googling like, oh, am I turning red?
That's like, just good for you, for knowing what it was.
You know,
I'm with that.
Age problem.
Yes.
you're not Gen Z.
No, I'm not.
What stuck out to me was, you know, you have this young lady, and not only interim executive or interim director, but she was put in charge of finances, which I know from having to do campaign finance reports in the past. It's not, you know, read a booklet and you know how to do everything. It really does take. But I saw a problem there. What bothers me probably the most is the fact that when we used to be able to make contributions, if I would give $100 contribution, my text messages and my emails blow up about giving more. So the fact that there was kind of that disconnect is the one troubling thing. But I think what really sticks out to me is the fact that they did, once they were made aware of it, they fixed it. And to our knowledge, there are no more violations or within what they around the second time. So I think it is somewhat of a clerical error, but I do believe, you know, it doesn't look right, and there does seem to be some sort of violation there.
Because you know, I guess my first thought was that amount of money, she'd be on a plane to go see President Biden. She's, you know what I mean, she's in the big leagues.
and it
You
was-
got 441,000.
was
They're
already-
gonna roll out a red carpet for you to do whatever, so.
In the material, Madam Chair, there's an article about, Ms. Rakowski being in the top 10 donors in the state of Ohio. She's number 2. It's be Renee Singh, who ran for governor, who probably lent himself money, but, yeah, I mean, she was listed as one of the top donors in the state, and to me, someone should have.
Yeah.
What?
Should, red flag.
Yeah.
Or I think,
But I think there should have, there wasn't that checks and balances.
Sure.
because she was the checks and balance, yeah.
Yeah.
So,
Yeah.
I would agree with, Mr. Lyle, and I definitely, believe that there is a violation, that, you know, make sure that people are doing their due diligence, doing these campaign finance reports.
Mr. Richter, and Mr. Lyle, thank you for bringing up the ORP, wasn't here.
Good, that's right.
Read about it in the press or something, I'm not sure. Mr. Richter, do you remember what the violation amount, was?
There were 3 separate cases.
Yeah, they were all.
There were 3 different. Let's see, there was the 3 different state and central executive committee. Don't tell me. What's the middle? There were 3 different, but you know, like the basic fund, the state candidate fund.
So they had like multiple.
Right, they had 3 different ones where they were late in filing their campaign finance reports. As I sit here, I can't recall how late they were. But they were late, and the commission found a violation and imposed a fine of $50 in each of those cases.
Something was wrong. I thought it was higher than that.
Well, and I think that's where it was at the preliminary review stage when they were dealt with, because the ORP came in and asked that good cause be found. And, I looked at it in terms of, okay, you had essentially, that was the first time for this committee. They were late, they were beyond a week to 10 days to 2 weeks of that time frame. And it was kind of, okay, you can't look at let's say the general fund and the state of candidates fund. Yeah, they're all related, but you look at them, to me at least, you look at them differently. You look at them separately, I should say.
The 11 fund or whatever.
Exactly. And so I said, $50 would be standard for that type of thing. And so that's what that was for, a late fine.
Well, that's where not the, yeah, where you said you actually have the same, they're not held to a higher standard.
Right.
When we were talking about finance.
Correct. Yeah.
Just because they're the ORP, you don't suck.
Right. I
look at those merits and things.
Right. And that was my, that was my, well, I was gonna say, that was my recommendation based on the fact that was for a late filing. Here, what you have is, the improper identification to $240,000. And I'm not saying you have to impose a fine of $440,000 or good cause. I mean, whatever is in there, but that's obviously the difference between that case and this case. And also, what I will say is you talked about, they did file their responses and take care of it. My recollection is here, the late filings have already been made. They were late, but they filed them, then the complaints were filed. Whereas here, it was only after we notified them that they filed.
Right, well, it's like
Correct. So that's true.
Well, I don't know where, Commissioner, where you are on the, I do not believe it's, a $50 type of violation. I also don't believe it's $1,000. I think there's a really good middle somewhere. It did disappoint me a little bit that, I never, already said, find no violation.
well,
I know it's par for the course, and I know that's how. However, our Republicans Party has more good calls. Like, yeah, we don't check.
I can find their.
I'm not comparing one against the other.
and I think, Steve, I mean, it's the way that the attorneys decided to proceed. I think it's almost like, so there's no hearing, obviously. It's just, I think, isn't this a first for the commission, Bill, that we have briefs to make a decision?
Yes.
So this is again, painting new law. Yes.
Mr. Richter. Commissioner Tavares and I, we like.
My head's at.
So I guess I would ask my colleagues, where are you at on the, I think there's a consensus that there's a violation. I think I've heard most of us at least say that at this point. Guess where are we on, right?
Here's what I'm looking back at my synopsis of the responses that were, and I can go back and file the actual response. The ORP said was they changed vendors after the mid-year filing in 2021. So when the 22 annual came around to be filed at the end of January, login information from the committee had not been provided to the new vendor, and so they could not log in to submit the report. Once the oversight was recognized, staff and party worked with the vendor to correct the problem and filed the reports as quickly as possible. The reports were about 3 weeks late, is what it said.
I remember that case now, and they were extremely unapologetic and acted like there should be no violation. They were kind of condescending, like, why were they even here over this? There was 3 of them, and they refuse to take any ownership or responsibility of it.
I'm not going to doubt your recollection of that, when it comes right down to it, Mr. Knight.
I have a question, so. Given my understanding is the standard is to treat the political parties as any other complainant or respondent. So if this was, you know, because towards my view, I don't believe that it's certainly not proven to me that anything was knowingly concealed or misrepresented. So now it's a violation of misreporting. So given if this were a misreporting violation from a candidate that then corrected it under this time frame, what would be our traditional recommendation?
If this were if this were the Geauga County, you know, Hamilton, or the Geauga County Democratic Party that filed their report late after this was brought to their attention, I probably put it in and they would, you know, I don't think they've been before us before, so I'd probably put it in the $50 category.
Okay.
For that. What I will say though is, I would also though take into consideration the fact that there's $400,000.
What statute would you base that on?
That's not based on statute. That is based on the factual circumstances that are present in this case. So.
Well,
and
I
one of the
guess if
factors-
it's not based on statute, then it's just, I mean, is it based on
Well,
precedent?
there-
Or is it based on like your opinion that larger dollar mistakes carry more weight?
I think there's an element to that. Yes.
But that's your personal viewpoint.
That's what I bring to the commission here, because there isn't a statute that specifically says it's gonna be $50. You know, because it's this late. That again is my experience in working with the commission over the years that brings that recommendation to the commission.
Okay, so what
So,
levels, at what level does that bar change? What's the rubric, right, that creates, because I mean, my view that answer Mr. Carraway is we should be fair and consistent and not just like winging that, well, we kind of think it ought to be, like, what is the OEC's rubric for large dollar mistakes?
Well, I mean, Lifestone was a huge. I mean-
Why is not that full outlier?
No, but I'm saying like, there was like, but it's,
And he was a con man and all
I
that.
understand all that, but I'm just saying like, his argument was, I'm misrepresented to the tune of whatever amount. So I'm just saying, $441,000 is a big misreporting.
That's why I'm asking for the rubric.
Yeah, that's what I.
Because I think that it's like my personal view of Blystone was they knew what they were doing. They were trying to push the letter of the law. And if you were
Absolutely.
to ask me, and I'm going to say it, I think you should be referred to prosecution.
I agree.
But, so I think this is on the complete end of the spectrum. I believe this was a mistake by a set of junior folks that should have been picked up and wasn't. So my opinion, it's a violation. I want to know what the rubric is for, you know, we should have a, you know, if it's not 50.
Standard,
Yeah, what's our standard and what are the gradients for that standard as opposed to, well, kind of sort of feels like could be X.
well, and where I will say there to that though is the thing that makes this case different from, you know, the standard that I would argue it's hard to have a rubric is you're dealing with a situation involving 12 separate contributions with that total over $440,000. And that's not something that we have seen before. And so, but I could say, oh yeah, here's what we've done in the past and here's what we've done in that kind of a situation. And so that's where You know, as I'm looking at this, yeah, you take into consideration, that the reports, yeah, I mean, to a degree, the reports were incorrect initially, but they weren't timely filed, so you take that into consideration. Then you look at it and say, okay, they updated, they corrected the mistake. But did they correct it prior to getting any kind of information on it? Did they go out and look into it and say, oh, okay, they made a mistake and they corrected it? And so they didn't do that until after they received our contribution. I take that into consideration as I'm making my recommendations on matters that.
Now contribution.
Yeah.
We need to set contribution.
You know, so I mean, those are some of the factors, and I appreciate what you're asking, but that's the kind of thing that makes it hard to come up with a rubric as such, because we haven't seen a case before like this, where you've got a situation where $440,000 of contributions was misallocated,
Fair enough.
you know, and so that's
Well, it
why.
wasn't- That's not accurate. It wasn't
This
misallocated.
was misreported.
Mis-
It
mis-
But it wasn't so long that she was
Sorry,
considered
you're
the
right.
number 2 contributor in the state of Ohio, so it went on for that length of time, so how long is that?
Well, that, yeah, that's the,
I'm just asking because I don't know.
well, she was only in there for 8 months.
No, but I'm saying, right, but
I
I'm
mean,
just,
in that position.
The competence was extended, but
Yeah.
I guess to answer your question based on that, my head is that take the 12 violations, $50 each, do a $600 fine. That's where my head's at.
I'm sorry, go ahead.
no, I'm sorry, this says impose a fine of less, not less than 100, not more than 1,000, so we're saying that we're saying the allegations, we're saying are not really, we don't agree with
We're,
the allegations.
yeah, asking where I'm at, to answer Mr. question, I don't feel this statute was violated. We have a reporting violation, that's why I was asking the questions on the reporting side.
Right.
So that's why, I mean, my simple math is 12 reporting violations, $50 each, $600. But it's a different statute violation than what we're discussing. It is what's on the complaint. I assume, are we allowed to do that, Phil? Are we allowed to,
Did it take,
Yes.
sorry, are we allowed to do that, executive director?
how long did it take between the time that they found out and then they amended their report? How long of a time period was that?
It was essentially 3 weeks late, because it was due on January 31, it was filed in late February. Late Sep-
With the correct information?
Oh, I'm sorry,
How long did it take them to amend it?
hold on a second.
Maybe that's irrelevant.
Because I don't know that off the top of my head. Maybe I can look at it.
So would it have been, would the contributions been attributed to Ms. Rakowski had someone not brought to their attention?
That's tough to know.
That's what I'm asking.
I mean, typically, when you know, it's like file, anybody, you file a report on a site on mine, you're not going back
Yeah.
in the report.
Probably didn't realize it.
You know, in an old report, so. These were, it was a pre and post. Right.
Sorry, it was a pre and post general for 2021. I'm looking to find out.
Because she really would have been getting, to Mr. Wilkie's point, she would have been getting some pretty heavy duty, invitations and whatever to be at that level. As a contributor.
Well, but that, to me, that only underscores that they don't even, I mean, they don't even know who she is.
I know, but that's my point.
You know,
Like,
that she's working for.
I know.
She was the executive director of Hamilton County. I thought, yeah, look at me, right? Cool, cool,
She
cool.
might have, yeah.
Probably had no idea why she thought she was getting them not shoved to that.
Probably from the old address, still getting them.
Yeah.
And we'll,
Oh, yeah.
they harvest the list, right?
Yeah.
She'll get a lot of VIP
She's been invited
invitations.
to the West Wing.
Yeah. So look, I don't think they knowingly concealed. I think we, mentioned that they did misrepresent contributions. There's no. They filed it wrong. They made a mistake. I'm comfortable with, I was somewhere between $500 and $1,000 for this. I think if it's $50, that it's You know, I think if it's 2,500, that's like totally excessive. So I'm fine with $500. That's where I'm at.
Per
You know, like total, I was 500, 1,000, whatever. I'm in that window. I think it needs to be bold enough to say, you know, pay attention to what you're doing. Don't do this again, but also it doesn't need to be.
Then I would say 100 per, well, but we're not going by that statute, so, yeah.
I'm, one of my first commission meetings, I remember there was a gentleman, sorry, I don't remember the county, his name was Bob Thurber. And, you know, he ran a push poll, right? And had no disclaimer, and he was defiant in his response. And I'm not comparing those two cases because they're dramatically different. Mr. Richter's recommendation was $50. And I thought it was woefully low or inadequate. Because, you know, a telecommunications piece that went out that had no disclaimer. And then he didn't admit any type of violation. And I think it was you. I said, well, what do we think it's gonna be? I think we did 250 or 500.
Like that.
It was much
It
more.
was, so you and I mainly discussed, I forget the number.
Yeah. So I think it needs to be, I am confident that Mr. Thurber, if he ever runs for public office again, will make darn sure that there's a disclaimer on his robocall. And I want to make sure that whether it's ORP or ODP or whomever, that the amount is more than minuscule, you know, whatever, they'll pay attention to it. Yeah.
I would agree with, Commissioner Knight, if we have a standard of $50 per violation times the 12, it would come up to $600.
Is that a motion?
Mr. Knight, you making it?
Sure, I would like to move that we find a violation, I'm sorry, 12 violations of the appropriate statute for misreporting. That we do a $50 fine for each of the 12 for a total fine of $600 in the matter.
Second.
A motion on the floor that's been duly seconded.
I just have a question. So are we identifying, so claims are Mr. Kowski, ODP, so.
My motion is to find ODP and to, yeah, in regards to no violation for Mr. Castle.
I second that as well.
Good pleasure.
Thank you. And I think I have that properly reflected. I was trying to see if in somewhere in the pleadings, they talk about when the reports were actually filed. I'm not seeing it, and the secretary's website doesn't reflect an amended filing date for those contributions for the 21 pre and post general. I mean, at least I'm running through quickly, so I mean, I could very well have missed it. But the complaint, just FYI, the complaint was filed on September 1 of 2022. These are for contributions that were a part of the, they were made in September 2021 in that time frame. So it's about a year ago. Okay, anyway, let's take with that, with the motion pending on the floor is to find that there wasn't 12 violations, as alleged in the complaint, for a total fine of $600 based on a $50 per violation, and find no violation, and that against the Democratic Party, and no violation against Ms. Gregkowski.
So for a year though, would it still be $50?
I would still be inclined to say,
That's what I want to know. Okay.
Mr. Lyle, I'm looking for votes now.
Yes, okay, so we have the motion on the
We
floor,
have a motion.
to accept $600 total, 12 violations, and that Ellen Rakowski is
No violation.
no violation. That's a yes for me.
Thank you. Mr. Caraway,
Yay.
Mr. Paulkey,
Yay.
Mr. Knight,
Yay.
Ms. Tavares,
Yeah.
Vice Chair Tavares,
Yeah.
Chair Kaufman.
I mean,
What does that fit? Is that like 6.5?
Okay, Normally when I collect votes, I either hit yeah, Y or N.
Yeah.
Putting it that. Putting it that. Since
So
I
we need to record the votes as 6-0.
I think it would still be 6-0.
Yeah, I'm saying, but you need to record it, so.
Yeah, that motion carries with the vote of
There you
6-0. The only new business, the only other business is that the next meeting is not today.
October.
It is October 26th. And it will probably be a long day.
Yeah, and it includes the completion.
I saw one of the documents had October 62nd.
And
Second?
were talking about it this morning.
I was gonna say, yes,
I think that is.
I originally printed it out October 16th.
Oh, yeah. I do.
All right, second. All in favor to adjourn the meeting, signify by saying aye. Aye. Sure. Yes. The vote carries with the vote.
Sure, I'm sure on the journey.
I'm pretty sure that you're out your.
Yeah, you too.
5 o'clock, usually.
I would anticipate it, yes.